Thomas E. Dobbs, State Health Officer of the Mississippi Department of Health, ETAL, Petitioners v. Jackson Women's Health Organization, ETAL, on writ of certiorari to the United States Court of Appeals for the Fifth Circuit, February 2022. Justice Alito delivered the opinion of the court. Abortion presents a profound moral issue on which Americans hold sharply conflicting views. Some believe fervently that a human person comes into being at conception and that abortion ends an innocent life. Others feel just as strongly that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Still others in a third group think that abortion should be allowed under some but not all circumstances. And those within this group hold a variety of views about the particular restrictions that should be imposed. For the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens. Then, in 1973, this court decided Roe v. Wade. Even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. It did not claim that American law or the common law had ever recognized such a right. And its survey of history ranged from the constitutionally irrelevant, e.g. its discussion of abortion in antiquity, to the plainly incorrect, e.g. its assertion that abortion was probably never a crime under the common law. After cataloging a wealth of other information having no bearing on the meaning of the Constitution, the opinion concluded with a numbered set of rules much like those that might be found in a statute enacted by a legislature. Under this scheme, each trimester of pregnancy was regulated differently, but the most critical line was drawn at roughly the end of the second trimester, which, at the time, corresponded to the point at which a fetus was thought to achieve viability, i.e., the ability to survive outside the womb. Although the court acknowledged that states had a legitimate interest in protecting potential life, it found that this interest could not justify any restriction on pre-viability abortions. The court did not explain the basis for this line. And even abortion supporters have found it hard to defend Roe's reasoning. One prominent constitutional scholar wrote that he would vote for a statute very much like the one the court ended up drafting if he were a legislator. But his assessment of Roe was memorable and brutal. Roe was not constitutional law at all and gave almost no sense of an obligation to try to be. At the time of Roe, 30 states still prohibited abortion at all stages. In the years prior to that decision, about a third of the states had liberalized their laws, but Roe abruptly ended that political process. It imposed the same highly restrictive regime on the entire nation, and it effectively struck down the abortion laws of every single state. As Justice Byron White aptly put it in his dissent, the decision represented the exercise of raw judicial power, and it sparked a national controversy that has embittered our political culture for a half-century. Eventually, in Planned Parenthood of Southeastern PA v. Casey, 1992, the court revisited Roe. But the members of the court split three ways. 2 justices expressed no desire to change Roe in any way. 4 others wanted to overrule the decision in its entirety. And the 3 remaining justices, who jointly signed the controlling opinion, took a third position. Their opinion did not endorse Roe's reasoning, and it even hinted that one or more of its authors might have reservations about whether the Constitution protects a right to abortion. But the opinion concluded that stare decisis, which calls for prior decisions to be followed in most instances, required adherence to what it called Roe's central holding, that a state may not constitutionally protect fetal life before viability even if that holding was wrong. Anything less, the opinion claimed, would undermine respect for this court and the rule of law. Paradoxically, the judgment in Casey did a fair amount of overruling. Several important abortion decisions were overruled in toto. And Roe itself was overruled in part. Casey threw out Roe's trimester scheme and substituted a new rule of uncertain origin under which states were forbidden to adopt any regulation that imposed an undue burden on a woman's right to have an abortion. The decision provided no clear guidance about the difference between a due and an undue burden. But the 3 justices who authored the controlling opinion called the contending sides of a national controversy to end their national division by treating the court's decision as the final settlement of the question of the constitutional right to abortion. As has become increasingly apparent in the intervening years, Casey did not achieve that goal. Americans continue to hold passionate and widely divergent views on abortion. And state legislatures have acted accordingly. Some have recently enacted laws allowing abortion, with few restrictions, at all stages of pregnancy. Others have tightly restricted abortion beginning well before viability. And in this case, 26 states have expressly asked this court to overrule Roe and Casey and allow the states to regulate or prohibit pre-viability abortions. Before us now is one such state law. The state of Mississippi asks us to uphold the constitutionality of a law that generally prohibits an abortion after the 15th week of pregnancy, several weeks before the point at which a fetus is now regarded as viable outside the womb. In defending this law, the state's primary argument is that we should reconsider and overrule Roe and Casey and once again allow each state to regulate abortion as its citizens wish. On the other side, respondents and the Solicitor General ask us to reaffirm Roe and Casey, and they contend that the Mississippi law cannot stand if we do so. Allowing Mississippi to prohibit abortions after 15 weeks of pregnancy, they argue, would be no different than overruling Casey and Roe entirely. They contend that no half measures are available and that we must either reaffirm or overrule Roe and Casey. We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution. But any such right must be deeply rooted in this nation's history and tradition, and implicit in the concept of ordered liberty. Washington v. Glucksberg, 1997, the right to abortion does not fall within this category. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from any other right that this court has held to fall within the 14th Amendment's protection of liberty. Roe's defenders characterize the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage, but abortion is fundamentally different, as both Roe and Casey acknowledged, because it destroys what those decisions called fetal life and what the law now before us describes as an unborn human being. Stare decisis, the doctrine on which Casey's controlling Roe's abuse of judicial authority. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. That is what the Constitution and the rule of law demand. The law at issue in this case, Mississippi's Gestational Age Act, contains this central provision, except in a medical emergency or in the case of a severe fetal abnormality. A person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. To support this act, the legislature made a series of factual findings. It began by noting that at the time of enactment only 6 countries besides the United States permitted non-therapeutic or elective abortion on demand after the 20th week of gestation. The legislature then found that at 5 or 6 weeks gestational age an unborn human being's heart begins beating. At 8 weeks the unborn human being begins to move in the womb. At 9 weeks, all basic physiological functions are present. At 10 weeks, vital organs begin to function, and hair, fingernails, and toenails begin to form. At 11 weeks an unborn human being's diaphragm is developing, and he or she may move about freely in the womb. And at 12 weeks the unborn human being has taken on the human form in all relevant respects. Quoting Gonzalez v. Carhart, 2007, it found that most abortions after 15 weeks employ dilation and evacuation procedures which involve the use of surgical instruments to crush and tear the unborn child. And it concluded that the intentional commitment of such acts for non-therapeutic or elective reasons is a barbaric practice, dangerous for the maternal patient, and demeaning to the medical profession. Respondents are an abortion clinic, Jackson Women's Health Organization, and one of its doctors. On the day the Gestational Age Act was enacted, respondents filed suit in federal district court against various Mississippi officials, alleging that the act violated this court's precedents establishing a constitutional right to abortion. The district court granted summary judgment in favor of respondents and permanently enjoined enforcement of the act, reasoning that viability marks the earliest point at which the state's interest in fetal life is constitutionally adequate to justify a legislative ban on non-therapeutic abortions, and that 15 weeks gestational age is prior to viability. Mississippi. Reasoning that viability marks the earliest point at which the state's interest in fetal life is constitutionally adequate to justify a legislative ban on non-therapeutic abortions, and that 15 weeks gestational age is prior to viability. Mississippi. 2019. The Fifth Circuit affirmed. We granted certiorari to resolve the question whether all pre-viability prohibitions on elective abortions are unconstitutional. Petitioners' primary defense of the Mississippi Gestational Age Act is that Roe and Casey were wrongly decided, and that the act is constitutional because it satisfies rational basis review. Respondents answer that allowing Mississippi to ban pre-viability abortions would be no different than overruling Casey and Roe entirely. They tell us that no half measures are available, we must either reaffirm or overrule Roe and Casey. We begin by considering the critical question whether the Constitution, properly understood, confers a right to obtain an abortion. Skipping over that question, the controlling opinion in Casey reaffirmed Roe's central holding, based solely on the doctrine of stare decisis. But as we will explain, proper application of stare decisis required an assessment of the strength of the grounds on which Roe was based. We therefore turn to the question that the Casey plurality did not consider. And we address that question in 3 steps. First, we explain the standard that our cases have used in determining whether the 14th Amendment's reference to liberty protects a particular right. Second, we examine whether the right at issue in this case is rooted in our nation's history and tradition, and whether it is an essential component of what we have described as ordered liberty. Finally, we consider whether a right to obtain an abortion is supported by other precedents. Constitutional analysis must begin with the language of the instrument, Gibbons v. Ogden, 1824, which offers a fixed standard for ascertaining what our founding document means. The Constitution makes no express reference to a right to obtain an abortion, and therefore those who claim that it protects such a right must show that the right is somehow implicit in the constitutional text. Roe, however, was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. And that privacy right, Roe observed, had been found to spring from no fewer than 5 different constitutional provisions: the First, Fourth, Fifth, Ninth, and 14th Amendments. The court's discussion left open at least 3 ways in which some combination of these provisions could protect the abortion right. One possibility was that the right was founded in the 9th Amendment's reservation of rights to the people. Another was that the right was rooted in the First, Fourth, or Fifth Amendment, or in some combination of those provisions, and that this right had been incorporated into the Due Process Clause of the 14th Amendment just as many other Bill of Rights provisions had by then been incorporated. And a third path was that the First, Fourth, and Fifth Amendments played no role, and that the right was simply a component of the liberty protected by the 14th Amendment's Due Process Clause. Roe expressed the feeling that the 14th Amendment was the provision that did the work. But its message seemed to be that the abortion right could be found somewhere in the Constitution, and that specifying its exact location was not of paramount importance. The Casey court did not defend this unfocused analysis, and instead grounded its decision solely on the theory that the right to obtain abortion is part of the liberty protected by the 14th Amendment's Due Process Clause. We discuss this theory in depth below, but before doing so, we briefly address one additional constitutional provision that some of respondents' amici have now offered as yet another potential home for the abortion right, the 14th Amendment's Equal Protection Clause. Neither Roe nor Casey saw fit to invoke this theory, and it is squarely foreclosed by our precedents, which establish that a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such classifications. The regulation of a medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny, unless the regulation is a mere pretext, designed to effect an invidious discrimination against members of one sex or the other. Geduldig v. Aiello, 1974. And, as the court has stated, The goal of preventing abortion does not constitute invidiously discriminatory animus against women. Bray v. Alexandria Women's Health Clinic, 1993.